Good morning, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and we are bringing you the preliminary hearing of Chad Daybell live. Let's listen in. They're saying they have no sound. There's says he can't hear the courtroom.
Yes, I know.
Joseph is.
Do you have your no one more?
Mm-hmm. We're working on the sound.
1 second.
The defendant, Mr. Daybell, and Alex Cox.
I'm going to stop you there. Who was Alex Cox?
Alex Cox is Lori's brother.
Okay. So you made contact with them. What happened?
I made contact with Alex and asked Alex if Lori was home.
How did he respond?
Judge, I'm going to object hearsay.
Mr. Wood,
Your Honor, this is a statement of a co-conspirator coming in. He is an unavailable witness because he's no longer living, but it's still a statement of a co-conspirator, and I think it comes in.
Mr. Pryor, let you respond to that.
Judge, I'd like to see the court documents that list Mr. Alex Cox as a co-conspirator. I don't believe those documents are presently in existence at this point, so I have nothing that supports that other than Mr. Wood's statement.
Mr. Wood,
Your Honor, the complaint alleges Mr. Daybell, Mrs. Vallow, conspirators known and known, and the probable cause affidavit clearly lists Alex Cox as a co-conspirator.
Mr. Pryor, it appears that Mr. Wood is explaining that because it is information communicated between co-conspirators named in a criminal complaint, it falls under the rule of non-hearsay, under the Idaho criminal rules, do you wish, or excuse me, the Idaho rules of evidence, do you wish to respond to that?
Judge, the complaint also lists known and unknown. So at this point, if we go by Mr. Wood's analysis, anybody could be listed or mentioned as a co-conspirator, and all sorts of information can come in. So at this point, I stand by my initial response, which is, at least from my reading of the pleadings and the current criminal charges that are filed, there are 2 people that are alleged in this thing. And at that point, that's what I believe the proper application of the rule is.
The court is going to overrule the objection. The court finds that Alex Cox is named in the criminal complaint. At this juncture, we're at a preliminary hearing stage where probable cause is the standard. Mr. Pryor, if there are other co-conspirators that are named or that are brought up here today, you may renew your objection, or you may renew your objection in a further time if you feel that the allegation has not been presented sufficiently enough to show that Mr. Cox is a co-conspirator. But I am going to allow it. Under 801, the exception that allows for co-conspirator communication to be admitted. So with that, Mr. Wood, you may continue to inquire.
Thank you. Detective, can you answer that question?
Can you ask it one more time, please?
Yes. So will you have testified you made contact with Mr. Daybell and Mr. Cox? What did you ask Mr. Cox?
I asked Mr. Cox if Lori Vallow was home.
How did he respond?
He stated she was not home.
Okay. What happened after that?
I asked Alex if JJ was home. I informed Mr. Cox why I was there is to do a welfare check on JJ. So I asked him if he was there.
How did he respond?
Initially, he didn't respond. He just looked at the defendant Daybell and didn't answer my question initially.
Okay. And then what happened?
I asked him again, and he stated that Joshua was with his grandma Kay in Louisiana.
Okay. How did you respond to that?
I told Mr. Cox that was unlikely because Kay was the one who originally called in the welfare check.
All right. What happened after that?
I asked Mr. Cox how I can get a hold of Lori and asked him for her phone number.
How did he respond?
He stated he didn't have it.
Okay. What did that make you think when he told you he didn't have his phone number?
Judge, I'm going to object.
Reason?
Judge, this witness can offer his recitation of the facts, but if we're going to start getting into the issue of whether or not he gets to present his impression in terms of what a third party had told him, I think is inappropriate.
Mr. Wood, can you repeat the question for the court?
The question was what Detective Hermosillo thought of Mr. Cox's response that he did not have Lori Vallow's phone number.
Mr. Wood, you want to respond to the objection made by Mr. Pryor?
Your Honor, I'm not aware of any rule that doesn't allow the detective to describe his thoughts on an investigation.
I'm going to overrule the objection. Mr. Hermosillo, you can give your thoughts as to what you were feeling at that time. Mr. Pryor, if that goes beyond thoughts, you're welcome to re-up your objection, and I'll take it up to.
Thank you, Judge. Thank you.
Go ahead, Mr. Wood.
Can you answer the question?
I thought it was suspicious because I knew that they had been close based on my initial investigation.
Okay. What happened after that, Detective?
I asked Mr. Cox where I could find Lori so I can make contact with her. And he stated that she was in apartment 107.
Okay. Once you learned that information, what did you do?
Myself and Detective Dave Hope then went to 107 to attempt to make contact with Lori.
What happened there?
Detective Dave Hope went to knock on the front door. As he was knocking on the front door, I saw the defendant Daybell driving towards me in his black Equinox.
Okay. And what did you do?
I stopped Mr. Daybell to further speak with him.
Yeah. Did you ask him any questions?
I did.
What did you ask him?
I asked Mr. Daybell when's the last time he saw JJ, and he stated that he saw JJ in apartment 107 in October.
Okay. Now, apartment 107, do you know who, you stated this was on 565 Pioneer Road. Do you know who apartment 107 belonged to, or who it lived, or who lived in that apartment?
Not at that time.
Okay. What happened after he gave you that answer?
I asked Mr. Daybell for Lori Vallo's phone number, and he stated he didn't have it.
Okay. What did you think when he told you he didn't have her number?
I again found it suspicious because I knew that they were married 2 weeks prior to my contact with Mr. Daybell.
Okay, and again, just for clarification, what was the date we're talking about now? What was that date?
November 26th, 2019.
Did you ask Mr. Daybell any other questions?
I did. I asked Mr. Daybell how he knew Lori Vallo, and he stated that he had only met her a couple times through Alex Cox.
Okay. What happened after that?
Detective Hope had come back to where we were speaking. I again asked Mr. Daybell if he had Lori's phone number, and at that point, he gave me Lori Vallo's phone number.
Okay, did you ask him why he hadn't given you that number?
I did.
And what was his response?
He stated that he felt like I was accusing him of something.
Okay. In your interaction with him, had you accused him of anything?
No.
Okay. What did you do in your investigation after that?
I broke contact with Mr. Daybell and called Lieutenant Ron Ball to respond to my location. Based on Mr. Daybell's actions, Mr. Cox's actions, what I was told about them hardly knowing each other, I felt there was something more going on with the whereabouts of JJ, so I wanted more officers over there so we could figure out what was going on. Okay.
And then what happened after that?
Lieutenant Ron Ball, Detective Dave Stubbs, and Officer Kellen Wett responded over to 565 Pioneer.
Okay. And then what happened?
Myself and Lieutenant Ron Ball attempted to make contact with Lori in apartment 175 and were unable to make contact with anybody in apartment 175.
Okay. What did you do after that?
We went to apartment 174, which was Melanie Boudreau's apartment.
And stopped right there. Who is Melanie Boudreau?
It's Lori's niece.
Okay. And then what happened?
We were unable to make contact with anybody there as well.
Okay. So what did you do after that?
I was instructed by Lieutenant Ron Ball to go to the prosecutor's office and obtain a search warrant.
Is that what you did?
I went to the prosecutor's office, yes.
Did you obtain a search warrant that day?
No, I did not.
Okay. Did you have any contact with Lori Vallow that day?
I did not have any contact with Lori, no.
Okay. Were you still with Detective Hope?
I was.
Do you know if he had contact with Lori Vallow that day?
He did.
Okay. Do you know?
Judge, could I have some foundation as to?
I can lay that.
All right.
You were with Detective Hope that day?
Yes.
Do you know if he ever attempted to call Lori Vallow with the number you were given?
He did. He attempted to call Lori Vallow on the way to the prosecutor's office.
Okay. And did he ever get in touch with her? Did she ever answer the phone when he called?
No, he was able to leave a message on her voicemail.
Okay. And were you with him when he did that?
I was not with him when he did that.
Judge, I'm going to move to strike.
Okay, reason?
Well, Judge, he has no basis other than what he was told, obviously. If he wasn't present during that conversation, I'm not sure how he can admit that conversation since he wasn't present for that. And the only way he would know that is if either Lieutenant Ball or someone else told him that that took place. It's hearsay at this point. It's not admissible.
Your Honor, we'll just move on. It's fine.
All right, that will be stricken.
I would do ask that it be stricken from the record, though.
That conversation will be stricken from the record, just so I'm clear, Mr. Pryor, the conversation between Mr. Ball and...
Your Honor, I believe it was Detective Hope.
I apologize. I said Lieutenant Ball. Lieutenant Ball?
Detective Hope.
Detective Ball. I apologize. I meant Officer Hope. I apologize.
That conversation will be stricken.
Detective, during your investigation that day, were you able to locate JJ Vallow?
No.
Okay. Did you, have you spoken with Detective Ball and Detective Stubbs about their investigation that day?
I have.
Do you know if parts of their investigation were on body cam?
It was.
Judge, I'm going to object again, foundation.
Mr. Wood? Mr. Pryor, the question was if Officer Hermosillo knew if it was on body cam. So I'm going to overrule that objection. That's just a question for Mr. Hermosillo. Obviously, what's in the body cam is probably a different story. You may proceed.
Thank you.
Mr. Hermosillo, you may answer that question.
It was on body cam.
Okay. Have you had an opportunity to watch that body cam?
Yes.
Okay. I asked you earlier if you were able
Judge,
to.
could we approach, please?
You may. Would you like to do that back in chambers?
No.
I'll instruct the media to make sure that recording is not taking place here.
All right. So the district attorney and Mr. Pryor, counsel for the defendant, Chad Daybell, have a bench conference going on right now. It's revolving around some conversations that took place as it relates to some body cam images. Now, this is a preliminary hearing, so the rules of evidence are somewhat relaxed and hearsay is usually admissible. One thing that was a little surprising was that the district attorney earlier on in this hearing tried to bring in statements made by Alex Cox, who's obviously deceased. The district attorney basically said, well, Your Honor, they're all charged as co-conspirators in this particular conspiracy, and therefore, let me see if I can actually do this, and therefore the statements are not hearsay, which is true. But normally, let me take these off here. Normally, the district attorney has to establish, and then the court has to make a finding that a conspiracy existed before those statements can come in. And it's what they refer to as, and this is really getting into the weeds here, but it's called the co-conspirator exception 801D2E. Looks like we're resuming again, so let's go back.
We'll go back on the record. Court took a brief sidebar to discuss an evidentiary issue. Mr. Wood, you may ask that question again, please.
Detective Hermosillo, have you watched the body cam video of Detective?
Yes.
Okay. Did you obtain a search warrant on November 26th?
On November 26th?
Yes.
No.
Okay. I'm going to call your attention to November 27th, 2019. What did you do in furtherance of your investigation on November 27th?
We were able to obtain a search warrant for apartments 175, 174, and 107 at
Okay.
565 Pioneer.
And what was the purpose of searching those apartments?
To locate JJ.
Okay. At this time, were you searching for Tylee Ryan?
No.
Were you aware of Tylee Ryan at this time?
No.
Okay. So where did you search?
All three apartments.
Okay. And just for clarity of the record, those three apartments are 175, 174, and 107 on 565 Pioneer Road?
That's correct.
Thank you. Were you able to locate JJ in any of those apartments?
No, we were not.
Okay. Did you find, what evidence, if any, did you find to suggest he had been living there in any of those apartments?
In 175, there was a half-empty prescription bottle of Resperdone and also a suitcase that had JJ's name on it.
Okay, and that prescription bottle, did that have JJ's name on it?
It did.
Was there anything else of interest to you in searching those apartments?
Yes.
What was that?
The apartments appeared to be lived in. There was food in the refrigerator, food in the pantry, furniture. The only thing that was off in 175 was it appeared that there was no clothes. Everything had been taken off the hangers, and there was no clothes in the dresser drawers.
Okay. Did all three apartments appear to be lived in at the moment?
No.
Oh, can you elaborate on that?
107 was completely vacant.
Okay. Did you obtain another search warrant that day?
We did.
What caused you to obtain another search warrant?
During the initial search of 175 in the master bedroom, a rental agreement was located for a self-storage unit on Airport Road.
All right. Do you know the name of that storage unit?
Self-storage.
Self-storage. Oh, okay. I apologize. I misheard you. Do you know the number of the storage unit?
I believe it was C52.
Okay. And did you execute that search warrant?
We did.
What did you find?
There was some winter clothing in a couple of boxes, a couple of children's bikes, and in the winter clothing, there was a couple personalized blankets that had the pictures, looked like family pictures that were sewn onto the blankets.
Okay. Detective, what city are those apartments located in?
I'm sorry,
What city were those apartments located in?
Rexburg,
Okay. And what county is Rexburg in?
Madison County.
Thank you. Detective, at the end of November 27th, had you located JJ Vallow?
No, we had not.
Okay. What was the next step in your investigation?
Well, our next step was we were just trying to locate JJ. We had obtained search warrants for cell phone data, spoke to numerous friends of the family.
Judge, could I get some foundation, please? That's a very broad statement regarding phone records and discussing witnesses with family.
So you're making an objection on foundational purposes, is that correct?
It is, Judge. Thank you.
Mr. Wood?
I'll lay some more foundation, Your Honor. As part of your investigation, did you try to locate individuals who may have known Chad Daybell or Lori Vallow?
Yes, we did.
Okay. Who were some of those individuals?
Family and friends.
Okay. Do you know any of their names?
Melanie Boudreau, Ian Pulowski, Gilbert Police had contacted family members in Arizona.
Okay. All right. Did you engage the help of any other law enforcement agencies?
We did. We asked for assistance from the FBI.
Okay. While you were searching for JJ Vallow, at any time did Lori Vallow or Chad Daybell, to your knowledge, ever call the Rexburg Police to report missing children?
No, in fact, we attempted several times to get a hold of Lori, and her cell phone was shut off. We attempted to get a hold of Chad and never gotten any return phone calls. And in fact, they retained an attorney and refused to answer any questions.
Detective, during your search for JJ, did that investigation ever grow to include Tyree Ryan?
It did.
Why was that?
In speaking with family members, we were also told that nobody
Judge,
had.
I'm going to object at this point.
What grounds?
Well, it's hearsay. If he's going to start, of course, nodding his head, obviously, if he's going to start reciting what other people have told him, other than what is permissible under the rules, that's hearsay, Judge. It's not admissible.
Mr. Wood, you wish to respond to that objection?
Yes, Your Honor, I think it comes in for the effect on the listener to explain what the investigator did.
Can you give me the specific exception under Rule 801?
Yes.
Are you looking at 803, Mr. Wood?
Yes, Your Honor.
And will you give me which subsection you're looking at?
So,
Your Honor, I think it comes in under 803.1. The present sense impression explains what Detective Hermosillo learned and why he did what he did based on that.
Mr. Pryor?
Judge, in response, that's not a present sense impression. What it is there's an investigation that's going on, and what Mr. Wood is attempting to do is to get statements from witnesses who are not here today. It's clearly hearsay, Judge. His initial response, obviously, in terms of why it comes in, was not appropriate, and this one's just as not proper in terms of a present sense impression. Not only hasn't been a proper foundation to suggest there's a present sense impression, which he needs to first establish that. Secondly, if this witness would like to talk about actions that he took, I'm not going to tell Mr. Wood how to get any evidence in, but if he would like to talk about any actions this officer took as a result of talking with other people, he can do that. But clearly, the statements of those other people does not come in. It's hearsay. It's not admissible under any of the exceptions.
Mr. Wood, any other response?
Yes, Your Honor. Again, it's not coming in for the truth of the matter. It's coming in to establish why Mr. Hermosillo or Detective Hermosillo and his team did what they did.
And Judge, that's not necessary for you to bring in the statements then. All you have to do is say, officer, and I'm not again telling Mr. Wood how to try his case, but quite honestly, Judge, if he suggests to this officer, officer, did you take any action based on what information you received from family members, we can move forward with this thing. But again, I stand by my initial objection. It is not permissible or appropriate for him to get in information from those other family members. There is another manner in which he can proceed if he wants to proceed that way. But getting those statements in is clearly inadmissible.
Mr. Wood, I'm going to sustain the objection as it pertains to specifics to what the family members stated. Those are hearsay. If there are specific statements that you're looking to get in that are not truth of the matter asserted, I'll let you continue and you can try to see what can happen. But if you're looking for specific instances or specific statements that have been made by the family members pertaining to the investigation, I'm going to sustain the objection as hearsay.
That's fine, Your Honor. Thank you. Detective, did you take any steps to learn if Lori Vallow had any other children?
We did.
Okay, what steps were those?
We spoke with family members. We spoke with her son, Colby Ryan.
Okay. And did you, in your investigation, did that investigation grow from searching just for JJ to searching for JJ and Tyler Ryan?
Yes, it did.
Thank you. Your Honor, I'd like to hand the exhibit or the witness exhibit, State's Exhibit 8.
Exhibit 8. Madam Bailiff, if you'll please show Exhibit 8 to Mr. Pryor. Mr. Pryor,
Judge, there's no objection.
Exhibit 8 will be handed to the witness. Mr. Pryor, just so I'm clear, there's no objection to Exhibit 8 being admitted. Is that correct?
That's correct, Your Honor.
Exhibit 8 will be admitted.
Your Honor, I'd also ask that the witness be handed State's Exhibit 9.
Any objection to that admission?
No, Judge.
Exhibit 9 will be admitted.
Detective Hermosillo, can you look at State's Exhibit 8? Are you familiar with that?
I
With that
am.
exhibit?
Yes.
And what is it?
It's a photograph of JJ, Tyler Ryan, and Alex Cox.
Okay. Do you know where that photograph came from?
I do.
Where?
It was obtained through a search warrant from Chandler Police Department from one of Lori Bellow's iCloud accounts.
Okay, and have you had the opportunity to review the pictures on that iCloud account?
Yes, I have.
And so you recognize that picture.
Yes.
Can you tell the court what is in that picture?
It appears they're in West Yellowstone National Park.
Okay. And who all is in that picture?
JJ, Tylee, and Alex Cox.
Okay. Do you know what date that picture was taken?
September 8th,
Okay.
2019.
Pardon?
September 8th, 2019.
Thank you. Can you look at Stakes Exhibit 9? Do you recognize that picture?
I do.
And have you seen it before?
Yes, I have.
Do you know where that picture came from?
Yes.
Can you tell the court?
It was also obtained through a search warrant from Chandler Police Department from Lori's iCloud account.
Okay. Do you know what date that picture was taken?
September 22nd, 2019.
Okay. And who is in that picture?
It's JJ sitting on a couch.
Okay. Detective, as part of your investigation, did you attempt to locate or let me rephrase that. As part of your investigation, did you look for proof of life of JJ and Tylee?
We did.
And what, for his purposes of your investigation, would suffice for proof of life?
We had set up a hotline through NCMEC, which is National Center for Missing and Exploited Children. We also had a hotline set up through the FBI, and we would receive hundreds of tips on possible sightings of JJ and Tylee.
Okay. And would you follow up on those tips and sightings as part of your investigation?
We would.
And is it fair to say that a photograph of the child that you could recognize as a child could be considered proof of life?
Yes.
Okay. Detective, have you found any photographs of Tylee Ryan after September 8th, 2019 that
No.
you can positively identify as being taken after September 8th, 2019?
No, we have not.
Okay. In your investigation, have you found any photographs after September 22nd, 2019 of JJ that can be positively identified as JJ?
No, we have not.
Okay. Detective, have you been able to verify through any tip or lead any other verifiable sighting of Tylee Ryan after September 8th, 2019?
No.
And have you been able to verify through your investigation, or find, I should say, through your investigation, any other verifiable sighting of JJ Vallow after September 22nd?
No.
Okay. Detective, are you aware if a Child Protection Act was filed for JJ Vallow and Tylee Ryan in Madison County, Idaho?
Yes, I am.
Were you involved in that?
I was.
How?
I was the affiant.
Okay. Do you remember when that was filed?
I believe it was January 16th, 2020.
Okay. And are you familiar with the initial order in that action?
Yes.
Did that order, let me ask this, did that order pertain to Mr. Daybell?
No, it did not.
Okay. Who did it pertain to?
Lori Vallow.
Did that order instruct Lori Vallow to do anything?
It instructed her to bring her minor children to the Rexburg Police Department or the Department of Health and Welfare within 5 days of being served.
Okay. And are you aware if Lori Vallow was ever served with that?
She was.
Okay. Do you remember what date she was served with that?
January 25th, 2020.
Okay. After that was filed, were you ever able to locate Chad Daybell and Lori Vallow?
Yes.
How did you do that?
Through tips and obtaining search warrants for cell phone data.
Okay. Where did you believe they were located?
In Hawaii, on the island of Kauai.
Okay. And did you ever have an opportunity to go there?
I did.
Okay. What did you do while you were there?
Judge, could I have some foundation, please?
Can you give some specifics as far as
Date, time, place,
Mr. Wood?
when he left, when he came back?
You got it. Do you remember when you went to Hawaii?
January 24th, 2020.
Okay. Do you remember when you returned from Hawaii?
I don't remember the date.
Okay. What island of Hawaii were you on, or did you travel to?
Kauai.
Okay. Oh, and again, what was the purpose of you traveling to the island of Kauai?
To assist the Kauai Police Department with serving Lori Vallow that court order.
Okay. And when you say the order, you're referring to that child protection order we just discussed?
Yes.
Okay. Did you do anything else while you were there?
We also assisted with surveillance.
Okay. While you were there, did you ever see J.J. Vallow or Tyler Ryan?
No, I did not.
Okay. Did you do anything else in furtherance of your investigation while you were there?
Yes, I did.
What was that?
I observed Kauai Police Department execute a search warrant on the defendant Daybell's vehicle and also their residence in Princeville.
Okay. Did you actually do the search, or did you just observe Kauai Police Department do that?
No, I just observed.
Okay. When you observed them, did you say you observed them search a vehicle?
Yes.
Do you know what kind of vehicle it was?
It was an SUV.
Okay.
Detective Hermosillo, I'm having a little bit of trouble hearing you. If you don't mind speaking up just a little bit.
Okay. I'll scoot closer. Is that better?
Yeah, and if you point that microphone up, but aim it at your chin, it'll make a better record. There you go.
All right. That vehicle, had you observed Chad Daybell and Lori Vallow in that vehicle?
Yes.
And when you observed the Kauai Police Department search it, were Chad and Lori in the vehicle at the time it was searched?
No, not at the time it was searched.
Well, let me rephrase that. Had you seen them in it directly before it was searched?
Yes.
Okay. Did you have an opportunity to observe the items that were taken from that vehicle?
Some of them.
Some of them? From what you observed, did you observe anything that would indicate that J.J. Vallow and Tyler Ryan had been in that vehicle?
No, I did not.
Okay. Did you help, or did you observe any other search warrants being served?
Yes, on their residence on Queen Emma Drive in Princeville.
Okay. Did you enter that residence?
I did.
Did you walk through the whole residence?
Not the entire residence.
Okay. What portion of that residence did you walk through?
The downstairs bedroom area and the upstairs living room.
Okay. In any of the areas you observed, did you observe anything that would indicate, did you observe anything that would indicate that J.J. Vallow had been there?
No.
Did you observe anything that would indicate that Tyler Ryan had been there?
No.
Okay. Detective, after you returned from Kauai, did you ever have a reason to go back to Kauai?
I did.
And what was that?
To also assist the Kauai Police Department with the arrest warrant of Lori Vallow.
Okay. Do you know what she was arrested for?
Minor or desertion of her minor children, 2 counts and 3 misdemeanors.
Okay.
Judge, can I also have some foundation, date, time, place?
Yes. When approximately did you return to Kauai?
Middle of February.
Okay. Do you recall what day you returned from Kauai?
A couple days after she was arrested, which was February 20th, so a couple days after that.
Okay. Did you ever have an opportunity to be in court with the defendant Vallow?
Yes.
Did you observe if she was notified of her charges?
She was.
Were you able to observe if the defendant Chad Daybell was present in the courtroom?
Yes, he was.
Detective, as part of your investigation, did you help execute a search warrant on Chad Daybell's residence?
Judge, could I have some foundation again? I don't mean to sound like a broken record, but if we could have a date, time, place, and I could get some of this in cross in terms of his representations, the last one about the middle of February. I would think that he'd have a more specific time in mind, but if we could have some specifics, I would appreciate it in terms of the date and time.
Are you talking about the courtroom issue or the warrant issue?
I'm talking about the warrant issue.
All right, Mr. Wood, it sounds like you asked the question if a warrant was done. I'll let Mr. Hermosillo answer that question. Then as far as the foundational issue, I'll sustain that objection. Mr. Wood, you'll need to lay some foundation.
Okay. Detective, as part of your investigation, on June 9th of 2020, did anything significant happen that day?
Yes,
Okay. Where did that happen?
in Fremont County at Mr. Daybell's residence,
Do you know the address?
202 North 1900 East.
Have you observed Mr. Daybell at that residence?
Yes,
Okay. What was your purpose of being at that residence?
to serve a search warrant of the property.
Okay. And did you, I believe you already said this, but just for clarity of the record, what county is that residence located at?
Fremont County.
Okay. Detective, what was the first thing you did in serving that warrant on June 9th?
We walked up to the front door to make contact with Mr. Daybell.
And what did you do after that?
We were able to make contact with Mr. Daybell's son, who answered the front door. He and another son led us into Mr. Daybell's room, where he was told that we had a search warrant for the property.
Okay, and then what happened?
Mr. Daybell came out of the room. He was able to sit in the kitchen area. He was allowed to speak with his attorney inside the kitchen area.
Okay. What happened after that?
Mr. Daybell was told if he wanted to stay on the property, which he could have, he would have to be accompanied by an officer for officer safety reasons. He was also told he was free to leave the residence if he wanted to.
Okay, and then what happened?
Mr. Daybell left and went and sat in his vehicle, which was parked in the driveway facing west off of 1900 East.
Okay. Your Honor, the state does have a demonstrative exhibit. We'd like to show the witness for purposes of clarity for the court and to further help the court understand what the detective is describing.
All right. Can you show that demonstrative exhibit to Mr. Pryor, please?
So as the prosecutor is getting his exhibits ready, this is the preliminary hearing for Chad
Mr. Pryor, an objection?
No, Judge.
Daybell. And
Mr. Wood, have you marked this exhibit?
We have not yet, Your Honor.
it's been pretty methodical and uneventful, and not a whole lot of new information has been gleaned from this preliminary hearing thus far. Believe that when the from the special agents that are expected to be called after Detective Hermosillo, that things will get a little more interesting. Clearly, you can see from the objections being made today that the defense believes that the prosecution is going to have issues regarding admissibility of statements.
No. Why don't we just mark it as the next number that you've got there? I believe the last exhibit that was marked as Exhibit 9. This would be Exhibit 10. It'll be marked as Exhibit 10. Mr. Pryor, just so I'm clear, any objection to the publishing and/or the admission of Exhibit 10 for demonstrative purposes.
I'm sorry, Judge.
Just so I'm clear, Mr. Pryor, any objection to the publication and/or the admission of Exhibit 10 for demonstrative purposes?
No, Judge, but what I would like to do is leave that out because I'm probably going to use that on cross of this officer. So if my preference is that if when Mr. Wood is done, that remain up so that I can use it again as part of my cross-examination, if I may, Judge.
That's fine. We'll probably move it to the side if there's something that happens after this between you and cross-examination, but we'll make sure that it's available to you at cross-examination.
Thank you, Your Honor.
Mr. Wood, you may inquire.
Before I do, Mr. Pryor, can you do that?
I can. Thank you, Mr. Wood.
And can the court and
I can.
Okay, Detective Hermosillo, do you recognize that exhibit, states Exhibit 10?
Yes, I do.
What is it?
It's an aerial photograph of Mr. Daybell's property.
Okay. Again, what county is that in?
Fremont County.
Now, do you recall Mr. Daybell's address?
202 North, 1900 East.
Okay. Detective, you were, correct me if I'm wrong, you were talking about what happened that morning. You served the warrant on Mr. Daybell. And then I believe you stated that he had gotten in his vehicle. Is that accurate?
That's correct.
And can you, Your Honor, I'm not quite sure how we're going to do this with the COVID restrictions and plexiglass. So I guess we'll just take it as it goes.
If you're going to ask him to leave the witness, we'll call it the cubicle, I will ask Mr. or Detective Hermosillo to put his mask on when he goes out there to point at the, there's a laser light over there too, Mr. Wood, if you'd like him to use that.
That would be perfect.
Okay.
Can you make sure, Detective, that laser light works?
Yep.
Okay. And can the court and defense see that?
Yes, thank you, Mr. Wood.
Okay, Detective Hermosillo, can you point to where you observed Mr. Daybell in his vehicle, like you were describing?
Mr. Daybell was in this vehicle here, facing westbound. This is 1900 East.
Okay. Where were you standing?
I was standing right here, and then I was at Mr. Daybell's driver's door speaking with him, just briefly asking him if he needed a code or anything out of the house.
Okay. And were you able to clearly view Mr. Daybell?
Yes.
Okay. What did you observe when you were watching Mr. Daybell?
Mr. Daybell was on the phone, sitting in the driver's seat. He had the phone in his right hand and was intently continuing looking over his right shoulder. He would look over his right shoulder for a while, break contact, talk on the phone for a second, and then he would continue looking back over his right shoulder,
Okay.
pretty intently over his right shoulder.
Did you have an opportunity to stand in roughly that same location that he had been in that day?
Yes.
Okay. For purposes of your investigation, did you attempt to orient yourself towards, in the same manner that you viewed Mr. Daybell orient himself?
Yes.
Okay. When you did that, what did you see?
Well, the second time Mr. Daybell had got out of the vehicle and went to the back of his vehicle, he was wearing a hat. He stood at the back of his vehicle looking in the same direction he was looking when he was inside the driver's seat. He took off his hat, ran his fingers through his hair, looked down towards the ground, put his hat back on, went back inside the driver's seat of that vehicle.
Okay. Now, a detective, I don't think you quite understood my question. I apologize, must not have been very clear. When you Did you ever stand in that same location that day?
I did. I was talking with Mr. Daybell while he was outside of his vehicle.
Okay. And did you ever orient yourself in the same direction that you viewed Mr. Daybell orient himself?
Yes.
And when you oriented yourself in that same direction, what did you find yourself looking at?
The north side of the property at the pond area.
Okay. Now, when you say the pond area, can you identify that?
This here is the pond area.
Okay.
And there's a tree just to the north, just on the outer side of the pond.
Okay. Now, Detective, you testified earlier you were there to serve a search warrant, correct?
Yes.
Who were Rexburg police officers involved in serving that warrant?
Yes, Rexburg was involved.
Were there other law enforcement agencies involved in executing that warrant?
Yes, there was.
Okay. What other agencies were involved?
Fremont County Sheriff's Department and the FBI ERT team.
All right. Do you know what ERT stands for?
Evidence Response Team, or Recovery Team, I'm sorry.
Okay. Detective, I'm going to call your attention to that pond area that you just previously pointed at. Did you observe the ERT team engage in any activity on that spot that day?
Yes, I did.
Okay. What did you first observe?
I first observed the ERT team marking off different areas and grading different areas in the backyard of Mr. Daybell's property.
Okay.
Judge, could I have some time and foundation in terms of approximately what time did he observe that taking place?
I'll lay that
Yes.
foundation, Your Honor.
Thank you.
Approximately what time did you see that happen?
Roughly around 9 in the morning.
What time, and to further lay that foundation, what time did you arrive at Mr. Daybell's property approximately that day?
Approximately 7 a.m.
Okay. So you just testified that around 9 you saw them grading off certain areas. What did you observe after that?
I observed the evidence response recovery team and also cadaver dogs working the entire backyard. So they worked the pond area and then they had marked off other areas inside the backyard.
Okay. And again, at that pond area, what did you observe after you saw the cadaver dogs and the grading?
They had found an area of interest and had started focusing on the area right underneath the tree.
Okay. And did you go over to that area yourself?
Yes, I did.
Okay. Were you able to identify yourself the area of interest they were looking at?
Yes.
Was there anything that stood out to you in that area?
Yes.
What was that?
There appeared to be, and this is just a guess, but about a 4x2 area of sod, what I can best describe as sod, in a shorter grass in an area of longer weed growth. So that 4x2 area stuck out based on the greenery around it.
Okay. And then what did you observe the ERT team do there?
They began pulling up the sod and topsoil.
And then what did they do?
They continued to methodically remove dirt.
Judge, can I inquire in aid of objection?
You may.
Judge, can I inquire as to whether the officer was specifically present at the time that these actions were taking place, or did he return back to Mr. Daybell's vehicle?
You may ask the question. Detective Hermosillo, I'm going to direct you to answer that question.
Yes, I was there.
You were there at the pond and the tree.
That is correct.
Okay. Thank you, Judge.
Mr. Wood, you may proceed.
Thank you. I believe you just testified they started removing, I think he called it sod. Is that accurate?
Yes.
What did you observe them do what did you observe as they removed that sod?
They removed some topsoil that was right underneath the sod, which revealed 3 large white rocks, flat rocks.
Okay, and can you explain for the court how those rocks were oriented?
In a row. So there was a large rock, a large rock, and a large rock.
Okay. After you observed that, what did you observe next?
They removed the rocks, and underneath the white rocks was some thin wood paneling.
Okay. And what did you observe them do with that paneling?
They removed the paneling.
Okay. And then what did you observe?
Initially, as soon as they removed the paneling, I could smell the odor of a decomposing body.
Okay, Detective. I'm going to ask you some questions on that. Through your training and experience, have you had multiple occasions to be around deceased bodies?
Yes.
What are some circumstances in which you would, in the course of your duties, be around that?
In the last 19 years, I've been on plenty of suicides that had been left in apartments that were decomposing, various states. Also unattended deaths, various ages of people. So during the 19 years, I've been to a lot of those.
Okay. And is it your testimony that, to your perception, that state of a body, a deceased body in some sense of decomposition has a specific smell that you recognize?
Yes.
Okay. And it is your testimony that you recognize that smell at that location?
That's correct.
Okay. After you noticed that smell, what did you observe?
I observed the ERT team methodically move away more soil from that area.
All right. And then what happened?
They removed some soil, and there was once they removed some soil, there was a black, what I can best describe as a black plastic bag with a round object protruding through the dirt.
Okay. What did you observe the ER team do after you saw that?
They dug a little bit more around the round object, which appeared to me to be the crown of a head, protruding through the dirt. They used a small, sharp instrument to cut through the black plastic.
Okay. And what did you observe when they did that?
There was a white plastic underneath the black plastic, and they also used the white instrument to cut through the white plastic.
Okay. And what did you observe when they did that?
I observed what looked to be brown human hair.
Okay. Once that was discovered, what did you observe the ER team do? What did you observe the ERT team do?
They continued to just work around the head that was exposed. They took pictures. They did whatever their team leader instructed them to do.
Okay. Was an item of interest eventually pulled out of that area?
Yes.
And can you describe what that item of interest looked like?
It was what appeared to be a small body tightly wrapped in black plastic, covered in duct tape.
Okay. After that item was recovered, what did you observe happen with that item?
That item was then placed into the back of the coroner's vehicle.
Okay. And did you have an opportunity to observe what the coroner did with it?
Yes.
About what time of day was this?
Roughly 11
Okay.
in the morning.
What did you observe the coroner do with that item of interest?
The coroner brought the bag up to Madison Memorial where it was placed in the morgue.
Okay. And were you in the vehicle with the county coroner, or did you observe that from another vehicle?
I was not in the vehicle. I was following directly behind the coroner's vehicle.
Did you ever lose sight of that vehicle?
No, I did not.
And did you watch that item of interest be placed in the hospital morgue?
Yes, I did.
Detective, while you were observing what happened at the ERT site, at that site we've just discussed north of the pond, did you ever leave that site for any purpose?
Yes, I did.
What did you do? Well, about what time did you leave that site?
Before noon.
Okay. And what did you do?
I assisted Sergeant Eric Wheeler in placing Mr. Daybell into custody off of a traffic stop.
Okay. Detective, after you observed the county coroner take that item of interest up to the Madison Memorial Hospital, did you return to the Daybell property?
Yes, I did.
What did you do there?
I assisted the other ERT members in excavating different areas on Mr. Daybell's property.
Okay. Can you show the court the areas you assisted in excavation?
And Judge, so that we have a clear record, could you also vocalize that as well, please?
That's fine. Mr. Hermosillo, I'm going to direct you to shine your laser pointer at that and also verbalize what you're describing, what you're pointing at.
I'm pointing to a fire pit on Mr. Daybell's property, just northwest of the fire pit. There is what we've referred to the pet cemetery, and it's just north of the pet cemetery where I helped excavate.
Okay. And that area that you just referred to as a pet cemetery, why did you call it a pet cemetery?
There was pets buried there.
Okay. Were you able to identify you said they're pets. So when you say pets, are you referring to non-human animals?
That's correct.
Okay.
And Judge, could I inquire again in terms of aid of objection?
You may.
Thank you. Officer, you had mentioned that there were pets buried there. Can you give me the source of the information that advised you that there were pets buried there?
I assisted in digging them up. There was a dog and a cat.
Did you dig up the entire pet cemetery?
I personally did not dig up the entire
Did
pit.
anybody dig up the entire pet cemetery?
I can't answer that.
Were you there?
Your Honor, I'm going to object. This line of question doesn't go towards any objection.
Well, he acknowledged that he had assisted in digging up a dog, at least a dog and a cat. He had mentioned pets. I think you ought to be able to inquire as to whether or not he went through the entire pet cemetery or not.
I'm going to overrule the objection. Detective Hermosillo, you can answer the question. Did you dig up the whole pet cemetery?
I personally did not. We were instructed to do different tasks. So when we started on one task, we would complete it and then we would move to something else. But there were several ERT members that were on scene that may have done that.
That may have done that, or did you observe anybody dig up the entire pet cemetery?
Again, Your Honor, this goes to a factual issue, not a legal objection.
Mr. Pryor, it appears that you're doing a cross-examination here. Which objection are you trying to lay foundation for?
Judge, I'll get the information through cross-examination. Let's move on.
Thank you. Why don't we take a brief recess? It is almost 10:30. We'll take a 15-minute recess and then we'll go back on the record at 11:15. So 10:45.
All right. Good morning, Crime Talk aficionados. This is Scott Reisch. We have gone live as we are watching the proceedings taking place in Idaho as it relates to the preliminary hearing for Chad Daybell. Now, as we've talked about this before, but obviously people that have not previously watched this channel, we like to explain what's going on in the legal world a little bit more in depth than what you're going to get on the evening news. So the preliminary hearing is taking place right now. It's a screening device to make sure that there's enough evidence for a case to proceed forward to establish probable cause. It's a much lower standard of proof than it would be at a trial. Now, here, the prosecutor has put up Detective Hermosillo from the Rexburg Police Department. And, I don't know what they do. It must have called central casting. Every police officer, detective these days seems to have the shaved head goatee, and he's up there testifying. And he is going through very methodically as it relates to what he did. There have been a few objections by the defense in this particular case. Mr. Pryor, on behalf of Chad Daybell, what he is objecting to, and he got a little bit of play on it early on, was the fact that there were statements made by Alex Cox when they being the police, were originally investigating, trying to locate JJ. There were statements by Alex Cox as it relates to hadn't seen the children, etc. Mr. Pryor objected, and the court ultimately allowed it in as an exception to the hearsay rule. Remember, an out-of-court statement by another person being offered for the truth of the matter asserted is hearsay. The person who said it has to come into court and testify to it and be subject to cross-examination. However, there are many, many exceptions under the hearsay rule, and one of those exceptions is the co-conspirator statements. Now, for a statement to come in, the statement has to be made in furtherance of a conspiracy, not just everything comes in that the person said if they have to establish that. Additionally, normally the court has to make a finding that a conspiracy in fact existed, and therefore the statement was then made in furtherance of that conspiracy. The court didn't do that, which is not really surprising here at the preliminary hearing today, because the rules of evidence are somewhat relaxed at the preliminary hearing. At trial, however, that will get a little more complex for the district attorney to do and to potentially prove, at least based upon the evidence that we have seen here right now. Now, Mr. Pryor is doing an okay job. Sometimes, my theory at a preliminary hearing is I want that guy to say whatever he heard, who he said it from, because you're locking those witnesses into those particular statements. The other people that they're being quoted may not necessarily have that same recollection, but he's taking the position that he's going to treat this like a trial and try to keep some evidence trying to keep some evidence out potentially that could be detrimental to his particular client. It's a tactical thing. You just have to, judge it based upon, being right there in the courtroom. And he obviously knows more because he represents the client. He's had an opportunity to talk with him. But in this particular case, the co-conspirator statements are going to be huge. And, a lot of people, yes, they found these bodies here on the property, but unless we have some more information other than I buried a raccoon, so to speak, it's going to be difficult for the prosecutor to potentially establish proof beyond a reasonable doubt at a trial. Do I think that these charges are going to go away today here at all? No. And at the end of the proceedings, the judge will explain the legal standard, and he will state that it's a very low standard of proof, and all the district attorney has to do is establish certain things as it relates to the delay of the evidence, a conspiracy to delay, hinder, prevent the discovery of the remains of JJ and Ty Lee. Obviously, you can see how a case develops where police receive a report, basically missing child. They go and, to these residents where Lori Vallow and her brother have separate apartments. But it all kind of comes together. The police receive information. They think it doesn't really make sense. There were a couple of questions that the district attorney asked of Detective Hermosillo as it relates to, what did you think? Or, frankly, that's completely irrelevant. It's speculation. A little surprised the court allowed that in, but it is a preliminary hearing. But really, it's like, okay, based upon the answers that you received, what did you do next? Should have been the response, not the some of the responses. One of the statements that the detective talked about when they were talking about whether they had seen Ty Lee or JJ at this particular point, and it says, they had called many locations, they had spoken with people in Arizona, but that the defendants had obtained attorneys and were not talking, and they weren't talking to the police. If the detective said that at a trial, that would be a mistrial. You can't comment based upon a defendant's silence in any way. It's not going to make a difference here, but at a trial, that would be a motion for a mistrial because somebody exercises their constitutional rights. That is not permissible for that negative inference to exist. And, the officer says that at trial, look out, it's coming, a motion for mistrial is coming. And guess what? Then you get to do it all over again. And in my experience, I swear the most mistrials have always come from detectives. Instead of just answering the question, they always try to get that little dig in, just a little bit, like they're exercising their right to remain silent. Boom. Okay, mistrial. There you go, detective. Hope you're happy. They always try to do that. They know they're not supposed to do it, but they do it anyway because they think the judge will give them a pass. So, we will see if that takes place, a trial. Hopefully the prosecutor will reel in Detective Hermosillo so that we don't have to have a trial in that regards. Now, one of the things that Chad Daybell's attorney, Mr. Pryor, is doing is he's making what they refer to as speaking objections. And a speaking objection is basically, instead of saying objection, hearsay, and then you let the prosecutor respond to say under what exception the hearsay exception comes in, he rambles on and explains why he thinks it is and that the person doesn't have any personal knowledge of it, and the judge says, fine, sustained or overruled. Most good judges don't allow speaking objections. Now, this is a preliminary hearing, so there's no jury, but most judges do not allow a speaking objection in front of a jury. Most good judges will say, come to the bench if it requires anything more than a 1 or 2 word response to note your particular objection in this particular case. We, obviously there was mention about iCloud accounts. That's where photographs were taken, were recovered from regarding the photos last seen in the government's exhibits 8 and 9 relating to Ty Lee, last seen September 8th, and then JJ on September 22nd from the iCloud account. So obviously, we've mentioned this before. I mean, these phones are a treasure trove of information. And if the police can get subpoenas or search warrants for those particular accounts, so much information is going to be there. I think that when we hear from the FBI special agents coming up shortly, we will hear much more information regarding the cell phone information. I also, what was interesting, and this is significant for legal issues down the road, When the search warrant was executed at the Chad Daybell residence on June 9th of 2020, apparently old Chad was still in bed. He was getting up. They told him he could stay in the kitchen, or if he was going to leave, there was going to be a police officer around him. But they did say, and the key was, if you heard the detective state, that he was free to leave. Now you think, well, what difference does that make? It's a huge difference, because if one is not free to leave when the police are conducting an investigation, conducting a search warrant, something along those lines, that you're under arrest. And so at that point, if you're under arrest and the police don't have probable cause, it could be an illegal arrest. And then all the things that would flow from that illegal arrest would be suppressed. The fruit of the poisonous tree doctrine that I'm sure a lot of people have heard about or are familiar with. And so the police always seem to indicate in this particular scenario that Chad Daybell was free to leave. And I totally agree. I mean, the man was allowed to go out and sit in his car. Police officers were sitting, nearby him, so to speak. The detective talked about clearly trying to, the detective can testify as to his observations of Daybell when he was out there and he was on the phone. Didn't say who he was talking to, because unless he knew, he would have no personal knowledge of that. That'd be speculation. But he says that he kept rolling, looking over to where the digs on the property were taking place, and that, he was trying to insinuate that he appeared nervous. So that was also interesting. The other thing is the court has ordered that the broadcast cannot include anything related to showing any exhibits. At one point, Government's Exhibit 10, and for those of you who do not know, the plaintiffs in civil cases are always the numbers, defense is always letters. Same thing in a criminal case. Normally, can't think I've ever seen anything differently, but the prosecution Okay. All right. So I think we had a little internet glitch there real quick, but so the court has entered orders that the media, the people, the pool reporter cannot take pictures of the exhibits. There is Government's Exhibit 10, and like I said, prosecution always numbers, defense alphabet. They're using a demonstrative exhibit. A demonstrative exhibit is not an exhibit like a piece of evidence that's been collected. A demonstrative exhibit is an exhibit that has been created to help the witness explain their testimony. That demonstrative exhibit, if this was at a trial versus a preliminary hearing, would not go back to the jury. It's simply something that can, like I said, it's a map to show where items were on the property, as we've heard from the testimony of the Detective Hermosillo, responding to Exhibit 10. He was pointing out where the, pet cemetery was in relation to where they found bodies in the house, where the vehicle was being posted as well, sitting there until Chad Daybell drove off. So, that's the difference between exhibits that will actually be admitted ultimately at a trial and go back. Now, the other thing is that the defense counsel for Chad Daybell is making objections as it relates to foundation. Now, if you want to get really technical, there's no such rule of evidence of lack of foundation. Really what it is lack of personal knowledge, as was explained to me many, many years ago by a federal judge who knew the rules of evidence like the back of his hand. But really what they're asking for is, hey, just you need to let me know, what date are we talking about? What is the speaker saying? Where was the conversation? Who else was present? Those types of information is what people often refer to as foundation. And really, it's just clarifying questions. It's things that it does help the jury to know when they're considering it ultimately, as well as the judge in this particular case, since it is the preliminary hearing. But it's also things that could have been covered on cross-examination. All right. But sometimes you do it as a defense counsel to throw the district attorney off. Now, the district attorney in this particular case, Mr. Wood, and I don't know if this is how they do it all the time in Idaho, or if they get up to go to a podium and ask questions. I know they're changing the rules on us apparently in the old COVID world, is we have to sit at our table so that we're not standing up, putting out disease or anything like that. But he's very methodical. You can tell he's got his checklist. And like I said, this is a preliminary hearing. He does not have to put on all of his evidence here today. He needs to establish a couple of things. He needs to establish the location of the offense. Where was it? Obviously the county in which the bodies were found. Why is that necessary? They have to establish venue. He has to present some evidence to present what they refer to as a prima facie case as it relates to the offenses charged. Here, that there was a conspiracy between Chad Daybell, Lori Vallow, Alex Cox, and others known and unknown to the grand jury to conspire to delay the hindrance location of the remains. They have to show a victim, obviously JJ and Ty Lee. Identification, that's the thing they always have to prove, is how do they know it's this particular person, Chad Daybell, that was part of this conspiracy that engaged in such conduct. And they have to show that the date and time of the location, because that's what's in the charging document. What date did this take place? That's all they really have to show at the preliminary hearing. And so, we'll see. He's plugging away. He's being methodical. He does not need to be Mr. Showman for this particular proceeding. So it looks like we're going back to the hearing. Let's watch. Hey, Frank.
We'll go back on the record here in CR 2220-755, State of Idaho versus Chad Daybell. Court took a brief recess. It's now 11:15. The witness, Detective Hermosillo, is still on the witness stand, still under oath. We're still continuing with direct examination. Mr. Wood, you may continue to inquire.
Thank you. Detective Hermosillo, we were discussing your observations of the ERT team in an area that you've identified as a pet cemetery, correct?
That's correct.
For purposes of clarity of the record, I'm going to kind of skip back to a couple things. You've described Mr. Daybell's house as being in Fremont County, correct?
Yes.
And just for purposes of the record, that is Fremont County in the state of Idaho, correct?
Correct.
You described Lori Vallow's apartment complex as being in Madison County.
Correct.
And again, for purposes of clarity of the record, that's Madison County in the state of Idaho.
Yes.
Thank you. All right, let's get back to where we were. You have testified that you observed the ERT team, and I guess that's redundant. I should just say ERT. The T stands for team. You observed ERT uncover the remains of what you believe to be a dog and a cat.
Correct.
What did you further? Do you recall approximately what time of day that was? And yeah, what time of day was that?
It was early afternoon. I'd guess 1.
Okay. While you were in that area, did you have a chance to further observe ERT excavate that area you referred to as the pet cemetery?
Yes.
Okay. What did you observe?
I had been away from that area, but when I returned to that area, they had already dug down and located what appeared to be a mass of burnt flesh and charred bone.
Okay. Do you recall approximately how deep down that was?
I don't recall how deep it was.
Okay. Did you observe ERT take that mass out of the ground?
Yes, I did.
Okay. This search that commenced on June 9th, did it finish on June 9th?
No.
Did it continue on to June 10th?
Yes.
Okay. When the search ended on June 9th, was the residence of Chad Daybell secured?
Yes, it was.
And do you recall, did you observe if security guards were placed there?
Yes.
Okay. Let's talk about June 10th. Did you observe that location? Let's go back to that cemetery location again. Did you observe any excavation being done on June 10th?
Yes, I did.
What did you observe?
ERT had gone back to the same spot where there was a mass of burnt flesh and bone, and began excavating around that the best they could.
Okay. And what happened?
They were ultimately able to dig completely around the entire mass to reveal what they were digging up.
Okay. And did they remove, again, that mass from that area?
Yes, they did.
Did you see what they did with it?
Yes.
What did they do with it?
They put it in a bag and placed it in the back of the coroner's vehicle.
Okay. Were there any other identifying features of that in that area or as part of that mass that drew your attention?
Yes, there was.
What was it?
There was a melted green bucket that it appeared that the burnt flesh had been placed in. Under the bucket was a partial human skull.
And was that bucket and what you've just described as a partial human skull, were those also, did you observe what was done with those?
Yes.
What was done with those?
They were also placed into a bag and placed in the coroner's vehicle.
Okay. And do you remember approximately what time those items were placed in the coroner's vehicle? Approximately?
Afternoon, maybe 3 or 4-ish.
Okay. For the purposes of your investigation, what else did you do on June 10th?
I followed the Fremont County coroner, Fremont County Detective Vince Kaikamanu and Ron Ball. We went to Boise to the Ada County Coroner's Office with the remains that were recovered that day.
Okay. Did you, before you left to go to Boise, did you have an opportunity to go to the Madison Memorial Hospital in
Yes.
Rexford?
Yes.
And what did you do there?
Recovered the remains found from the first day as well.
Okay. And you observed what you recognize as those same remains?
That's correct.
Okay. Detective, I'm going to call your attention to June 11th. What did you do in furtherance of your investigation that day?
We were at the Ada County Coroner's Office.
Okay, and let me stop you real quick. About what time did you get there?
We arrived there on June 10th.
Okay.
That day on June 11th, we got there in the morning.
And let's go back to June 10th really quick. When you arrived in Boise, what was the first thing you did there?
We went to the Ada County Coroner's office.
Okay. Do you remember approximately what time you got there?
Evening,
Okay. All right. And now back to June 11th. Approximately what time did you return to the coroner's office?
early morning.
Okay. Detective, once you arrived on June 11th, what did you do in furtherance of your investigation?
Observed the autopsies of those remains that were recovered.
Okay. Now you've discussed two separate, I'll at this point call them items of interest. Did you recognize those items of interest again in the coroner's office?
Yes, I did.
Okay. And do you know if those items had been secured there the night before?
They had been.
Okay. Once you arrived in the autopsy room, what was the first thing you observed?
The first thing I observed was the black bag that was covered in duct tape that had been removed from the area underneath the tree by the pond, was placed on the table.
Okay, and you recognize that as the same black bag?
Yes.
How did you recognize that?
The duct tape and the black plastic that had still had dirt all over it.
What did you observe? Who was with you?
The medical examiner was in the room, Lieutenant Ron Ball, Detective Vince Kaikamanu, and the Fremont County Coroner, Brenda Dye.
Okay. Was there a medical examiner there?
Yes.
Do you know who he was?
Garth Warren.
Okay.
I'm sorry, Judge,
Garth Warren.
And you've testified you observed those proceedings?
Yes.
Correct. Once that bag was, as you testified, moved to the table, what did you observe was done with it?
The ME grabbed a small sharp instrument and cut down the middle of the black plastic.
Okay. And what did you observe?
I observed a small child in red pajamas, red pajama shirt, red pajama pants, black socks that had the word Skechers in orange across the toes. I also observed a light and blue blanket that had been placed on top of him.
Okay. Detective, were there, when you observed what you perceived to be a child, was there anything that drew your attention?
Yes.
Can you describe for the court what drew your attention?
The amount of duct tape that was covering the body.
Okay. Where was that duct tape located?
On the head, arms, and feet.
Okay. Let's talk about the head area. When you looked at the head, what did you observe there?
The head had a white plastic bag over the top of it. It appeared to be a normal trash bag, had a red drawstring. It appeared to be the expandable type of trash bag with the waffle style pattern on top of the head.
Okay. And you had mentioned duct tape there. Where did you observe the duct tape?
There was duct tape that was tightly wrapped around this way, tightly from his chin to his forehead area. several layers of duct tape tightly wrapped.
Okay. What did you observe the medical examiner and his team do with that material?
They ended up using a small sharp instrument and cut down the middle of it to expose what was underneath.
Okay, and when they exposed underneath, what did you observe?
An additional piece of duct tape that was stretched from jawline to jawline across the mouth.
Okay, and when you say across the mouth, at this point, were you looking at this child's face?
I was.
Okay. As you looked at this child's face, did you recognize this child?
Yes, I did.
How did you recognize this child?
From the hundreds of photographs and video I've seen over the last 8 months, I recognize that to be the same little boy that was laying on the table.
Okay, and can you, who was that little boy?
Joshua Vallow.
Were there any features that helped you recognize him?
Yes.
What were they?
He had the same style haircut that he had in the videos that I had seen and the photographs I had seen just prior to my welfare check with him in September, the last photograph I had seen on September 22nd. And that was shaved on the sides and longer on top.
Okay, thank you. Were there any other items of, were there any other items of interest to you on that body?
Yes.
Can you just, what were they?
His hands were folded about chest high,
Detective, can you lift that a little bit higher so we can see?
folded like this, chest high. He had duct tape continuously wrapped from elbow all the way around his arms, over his hands, all the way to his right elbow. Several layers of duct tape that were tightly wrapped. And the best way I can describe it is he had a ball of duct tape over where his hands would be.
Okay. Was that duct tape removed?
Yes, it was.
And what did you observe after that?
His wrists were also bound with another layer of duct tape.
Okay. After that, was there anything else that caught your attention about the way this child was found?
Yes, I noticed that his ankles were also bound with duct tape as well.
Okay. After you observed that, did you observe the autopsy of that child?
I did.
Okay. Detective, upon the conclusion of that autopsy, did you witness another examination that day?
Yes, I did.
Do you remember approximately when that examination started?
In the afternoon.
Okay. What did you observe in that second examination?
I observed the same melted green bucket with the charred flesh and charred bone that was located on Mr. Daybell's property that was now sitting on the table in the medical examiner's office.
Okay, thank you. Your Honor, the state has no further questions at this time.
Thank you. Cross-examination, Mr. Pryor.
Thank you, Your Honor. Officer, I'd like to go back to the initial contact with Mr. Daybell.
Mr. Pryor, will you pull that microphone closer to your mouth?
I apologize, Judge.
Thank you.
Thank you. Can you hear me okay, officer?
Yes, sir.
Thank you. I'd like to go back to the initial contact with Mr. Daybell. And again, in November, when was that date, sir?
The initial contact with Mr. Daybell was on the 26th of November 2019,
At approximately what time, officer?
early morning hours, around 9, I would say.
Okay, was that contact recorded?
It was not.
Is there a reason why you didn't record that contact?
It's not common practice for detectives to carry body cams.
Is it common practice for detectives to record conversations with witnesses when you interview them?
It is.
Can you understand why it's important that an interview with a witness is recorded?
Yes.
And it's important to record a witness or an interview with a witness so that we get the factual statements made by people recorded accurately. Would you agree with that?
I would.
And it's important that when we make statements and we make representations regarding statements that people make and observations, that they're accurate observations, right?
That's correct.
And one of the best ways to do that is to record those observations. Would you agree with me?
I would.
Okay. This was somewhat of an important case, was it not?
Not at that time. It was just a welfare check.
Okay. And then this welfare check turned into an interview with Mr. Cox and Mr. Daybell, however, correct?
Correct.
At any time, did you think that maybe you should have recorded this?
No, sir.
Okay. Did you record any of the other interviews with any of the other witnesses throughout your investigation?
I did.
And whose interviews have you recorded?
Melanie Boudreau's interview.
Then let's stop there. How many times did you talk with Melanie Boudreau?
Objection, this exceeds the scope of the direct.
Mr. Pryor, before we go any further, I'm hearing a shutter. Can the media please turn off the shutter sound? It's impeding my ability to hear the attorneys from both the state and the defense. Mr. Pryor, let me go back there. Mr. Wood, the objection is based upon exceeding the scope of the direct. Mr. Pryor, I'll let you respond to that objection.
Well, Judge, throughout his testimony, he made at least a couple of references to interviewing other members of the family and having conversations with them about various facts in this as part of his testimony with Mr. Wood. Quite honestly, if he's talking as Mr. Boudreau is one of those folks that he gained information from, one, I'm going to get into what information did he gather from them, and two, whether or not that's been memorialized in the form of a recording. So I think it is relevant, and I think quite honestly, it's permissible inquiry in this particular case.
At this point, Your Honor, he's asking for hearsay information, and again, he's way outside the scope of what Detective Hermosillo testified to.
Mr. Pryor, as it pertains, I think there were a couple questions as to a search of an apartment that belonged to Ms. Boudreau. I think that there was some brief questioning about questions of family members, but as far as the depth of those conversations, your objection was that they were hearsay. I agree with Mr. Wood, they are hearsay. Tell me where you're desiring to go. If you're just laying some foundation or getting some information about the communication, when it happened, etc., I think that that's completely relevant and it's completely within the scope. If it's beyond that, tell me what your argument is.
Well, Judge, quite honestly, I'm not necessarily seeking the exact information that those particular witnesses provided to this officer. What I'm trying to seek is a timeline as to exactly who he spoke to and when, and where he gathered this information. And as part of seeking that information as to who he spoke to, when he spoke to as part of this case, I would like to know whether or not that's a recorded conversation, so I am afforded the opportunity to look at what this officer testifies to today and compare it to what those recordings are. And I think it's important that I be afforded that opportunity, and as part of this, it's a preliminary hearing. Preliminarily, I would like to know whether or not this officer recorded the conversations.
With that, I will allow the questions pertaining to who he spoke to and when he spoke to them, whether or not they were recorded. But as far as the substance of those conversations, I will sustain the objection that Mr. Wood has raised as far as hearsay.
All right. You spoke with Melanie Boudreau, is that correct?
Yes, sir.
And how many times did you speak with her?
One time.
And when was that, sir?
December 3rd, 2019.
Was that as part of the investigation of the welfare check?
Yes, it was.
Okay, was there any other inquiry in there as to, were you at that point, had this moved into an area of trying to decide whether there had been any foul play with JJ or Tylee?
I was asking Miss Boudreau how we could get a hold of Mr. Daybell or Lori Vallow.
Okay, and that's to inquire as to the whereabouts of JJ at that time?
That is correct.
What about Tylee? Had it moved into that as well?
I did ask about Tylee.
Okay, at this,
Again, Your Honor, I'm going to object again. He's now asking for information from those interviews. It has nothing to do with the scope of the direct examination.
I'm not asking for information from Ms. Boudreau. I'm asking what this officer did as part of his investigation. Judge, we've just spent 2 hours listening to this officer talk about all of the steps in detail that he's done as part of his investigation. I think, quite honestly, I ought to be able to ask some very basic questions about what witnesses he interviewed as part of that investigation. I can't even fathom how that's not allowable inquiry. And I think, quite honestly, I don't know if Mr. Wood doesn't want to give me the information, or if this officer doesn't want to give me the information, but clearly I ought to be allowed to inquire as to what this officer did as part of his investigation.
As it pertains to the inquiry of whether or not Tylee Ryan was discussed, I'll allow that question. I'll have the officer answer that question. The deeper substance of that conversation, I agree, is beyond the scope.
Was part of your inquiry to discuss Tylee as well?
Yes, it was.
So this had gone beyond the welfare check of JJ. It had gone to, we're trying to find out if there's any sort of issues regarding JJ and Tylee at this point. Is that correct?
Yes, we were. Yes, we were.
Were you significantly concerned about their whereabouts in December?
Yes, we.
Melanie Boudreau, was that a recorded conversation?
It was.
Okay. And you provided that to the prosecuting attorney,
Yes.
as well as a statement of your complete interview with Judge, I heard a noise, I'm sorry.
I think it was someone's chair.
Okay, as well as a complete dissertation of what that interview involved. Is that correct?
Correct.
Okay. So in December, it was important that you record that conversation. What other family members did you discuss the case with? Let's try Garth. Did you talk to Garth?
I didn't personally talk to Garth.
You did not?
No, I did not.
Okay. Did you talk to Emma?
I did not personally talk to Emma.
Did you talk to Melanie Gibbs?
I did talk to Melanie Gibb.
You did?
Yes.
How many times?
By what date, sir?
How about from the time you started investigating this in November until yesterday?
Your Honor, this is far beyond the scope of the direct. A preliminary hearing, as the case law states, it's in no sense a trial. Not a trial. It does not require the same formality and precision observed at a trial. The state is not required to put on every bit of evidence it has. And the scope of the cross-examination should be limited to the direct. At this point, defense is using this as a fishing expedition to try and find out everything that they may want to know, but that is not the subject of this preliminary hearing. This is a probable cause hearing. That's why we're here. It's not a hearing for the defense to ask every question they may want to ask.
And Judge, when a prosecuting attorney elects to spend 2 hours with a witness going into what I call significant detail about every aspect of this case, at that point, this prosecuting attorney opened the door to allowing me to inquire about all of this stuff. Quite honestly, he doesn't get it both ways. He doesn't get to say, I'm going to have this officer talk in great detail about every facet of this case from the beginning of his investigation through the end, all the way to the autopsy, and say, oh, Mr. Pryor, I'm now going to object to you inquiring and seeking information about the steps that were taken as part of this investigation from beginning to end. He doesn't get it both ways. It works so that I get a fair opportunity to inquire of this officer. I'm not asking of substance of those witnesses. I understand, and I understand completely the hearsay rules. But quite honestly, Judge, I'm dumbfounded by the fact that he's objecting, because I'm trying to find out who this officer spoke to and whether or not those questions and those conversations were recorded. This is not delving into specifics about each of the individual witnesses. I clearly should be permitted to go down this road.
All right, the court's going to take a brief recess here. I'm going to look at one thing that I have a question about. We're going to take 5 minutes, and then we'll go back on the record and proceed with the cross.
All right, welcome back. This is Scott Reisch of Crime Talk, and as you can see, we've been bringing you the preliminary hearing of Chad Daybell, and the court just took another break. Normally, the courts usually begin 8:30, 9 o'clock when they're in trial or a preliminary hearing, and then they take a break about an hour and a half into the proceedings. We simply started with the cross-examination roughly about 15 minutes ago, and there's some objections regarding the scope of the cross-examination that Mr. Pryor should be allowed to go into. Now, Pryor is much better than Mr. Means, who's Lori Vallow's attorney. Clearly, you can tell from Pryor's statements in court, he knows what he's talking about. And in all honesty, I think he's correct when it comes to the scope of the questioning. The prosecutor opened the doors to the line of questioning where he's saying, what did you do during your investigation? Like, okay, let's talk about your investigation. That is at issue. Now, does he get to sit there and, go into every question that he would like answered? He knows how many times that the detective had spoken with Miss Boudreaux. It's going to be in the discovery. So nothing. I don't think that Mr. Pryor is doing anything inappropriate. In fact, he's representing his client, and is some of it for a little theatrics? Yeah, probably, maybe, probably more for client control issues. The client wants to know that his attorney is zealously representing him. At the end of the day, does this line of questioning going to make much of any difference whatsoever as it relates to the proceedings as they are, whether this case is going to be bound over? No. But it's just, this is the defense attorney establishing with the district attorney and the court that, hey, I'm going to fight for this guy. I know everybody in the country hates this guy. Everybody in the state of Idaho hates this guy. Probably everybody in the courtroom hates this guy. But guess what? It's my job to zealously represent him. And therefore, I'm going to make these objections and fight for my client. So we'll see what the court's going to allow. Certainly when it comes to the scope of the cross-examination, you should be able to say, all right, you spoke with Miss Boudreaux. And like I said, it's a preliminary hearing. The rules of evidence are relaxed at a preliminary hearing. And so normally the judge would allow the defense attorneys to go into it. But, like I said, you're not going to get there and sit and take a deposition for 7 hours of what time did you sit down with him? What time did you start the conversation? Where was each conversation held? They're not going to get into that. If he's got a specific question, the judge should probably tell him to answer it and go from there. We also did learn right before Detective Hermosillo was done testifying for the prosecution and turned over to the defense that he was present and observed the autopsies of the remains found at the house. Obviously, the first person that he talked about was J.J. Vallow, and obviously this can be a little graphic, but in this particular case, they laid the body out. He was in a coroner's bag. They unzipped it, and the child that was there had on red pajamas, red socks, and he had a white and blue blanket with him at the time, and described, that there was a garbage bag over the child's head, over JJ's head, and that it was duct taped around the top, basically eye level, so to speak. There was no testimony as it related to the cause of death, but one would certainly have to wonder if, in fact, it was asphyxiation. Probably hear from other witnesses who will testify to that. And those who are, a little squeamish, so to speak, this is the welcome to, criminal law. This is what you do. And at trial, the jury is going to get to see the photographs of the autopsy. Will they get to see all of them? No. The prosecution will only be allowed to submit just enough to basically, show what happened, the state of the body at the time, and not going to show every photograph. Normally in an autopsy, they take, it could be 50 to hundreds of photographs, depending on the particular case. At a certain point, they become prejudicial. And so usually the prosecution is going to have to, usually is limited by the court saying, give me your 5 best photos that you want to use. All right. It looks like they're going back on the record here. So let's go back to the proceedings. We'll be back when they take a break.
Yes, for the recess, there was an objection made by the state. That objection was based upon going beyond the scope of direct examination of Detective Hermosillo. Mr. Pryor responded with the argument that he was inquiring into facts of the investigation. The court initially overruled the objection and stated that I would allow the questions pertaining to who was spoken to, whether that conversation was recorded, when the conversation took place in the course of the investigation. I will stand by my ruling that I will allow Mr. Pryor to continue to inquire of the witness as to that state of the investigation. When it comes to the substance of those interviews or inquiries of the witnesses and or family, I'm going to sustain Mr. Robb's objection going forward that those will be unallowed or disallowed based upon hearsay. I think there's also a scope of the direct that would also come into play at that point. So, Mr. Pryor, if you'd like to proceed with the questioning of Mr. or Detective Hermosillo on cross, you may do so.
Thank you, Your Honor. Detective, when we were on the subject of Melanie Gibb, you spoke with her as well, is that correct?
That's correct.
Was that a recorded conversation?
I think one of them, the last one was.
Well,
When I spoke with her, we were on the phone. She was in Arizona and I was on a cell phone.
did you ever have the occasion? Now, my recollection, and correct me if I'm wrong, officer, my notes seem to reflect that you said you spoke with Melanie Gibb once. Was I incorrect in my notes?
No, I had spoken with her once in person.
Oh, once in person, okay.
And then on the phone the rest of the times.
Okay, and the date that you spoke to her in person, where was that location?
That was in Salt Lake City.
And the date of
Or
that?
Provo, I believe. Provo.
And that discussion in Salt Lake City was on what date, sir?
I don't recall the date.
Okay, all right. Now, you said it was Salt Lake City, it was Provo, was it not?
It was Provo area, yeah.
Provo area, not Salt Lake City, correct? And as part of that discussion, you drove down to Salt Lake City to interview her, is that correct?
That's correct.
And accompanying you on that trip was Lieutenant Ball, is that correct?
That's correct.
And also accompanying you on that trip was Mr. Wood, is that correct?
Yes, sir.
And do you have any recollection of during that one-to-one face-to-face interview between you, Mr. Wood, Lieutenant Ball, and yourself, and Melanie Gibb, was that recorded at any time?
I believe Lieutenant Ball had recorded that conversation.
You believe or you know?
I believe he recorded the conversation.
You did not record it?
No, sir.
Who was the head investigator of this investigation at this point?
I was the lead investigator,
Okay.
but he was the supervisor on scene.
Okay, and as the lead investigator, you chose not to record that conversation, is that correct?
I did not record that conversation.
And as the lead investigator, you chose not to record that conversation. That was an affirmative decision not to record the conversation.
Objection asked and answered.
I didn't get the question.
Sustained. You can move on, Mr. Pryor.
And then there was a phone conversation with Ms. Gibb, is that correct?
That is correct.
When was that?
That was in December sometime.
Is there a reason you don't know the specific dates? In a number of instances here, we've had occasions where you seem to suggest the month, but you don't know the specific date. Is there a reason behind that?
Those weren't super important dates to me. I interviewed a lot of people throughout the last 8 months.
Okay, and as a preparation for this hearing, did you review your reports and your supplements as part of your preparation to testify today?
I did.
Okay. And in spite of reading that supplement and refreshing your recollection, he said this, and if he's going down the road of hearsay, Judge, this has already been ruled on.
Your Honor, it calls for hearsay.
I'm going to overrule the objection. Mr. Pryor, you may continue with the question. I believe the question was, is it possible?
Right, is it possible that Mr. Daybell said, I don't know her as well as Alex?
No, that's not what I remember.
Okay. But you've already acknowledged that your recollection and the number of facts may not be completely accurate. Is that correct?
Objection argumentative.
Sustained.
Do you have a clear recollection of every statement made by every single witness in this case, sir?
Objection argumentative.
I'll allow the question.
Do you have a clear recollection of every statement of every witness made in this case, sir?
No.
Do you have a clear recollection of every date and the substance and time of every date as part of your investigation in this case?
Objection relevance.
Mr. Pryor?
It goes to his recollection, it goes to bias, Judge.
I'm going to overrule the objection. You may answer the question, Mr. Detective Hermosillo.
Could you ask it again, please?
Just the recollection of every date and time in this case as part of your investigation.
No, I don't.
And you would agree with me that it's possible that Mr. Daybell said that I don't know her as well.
Objection asked and answered.
Mr. Pryor, there's an objection as to asked and answered.
Judge, I laid the foundation and went down the same road, but the question is slightly different. Is it possible that you made a mistake about whether or not Mr. Daybell stated what you claimed he stated?
Mr. Wood?
Your Honor, at this point, defense is clearly trying to get in a statement of his own client. That's hearsay. There's no exception for it. If he wants to get in Mr. Daybell's testimony, he can put Mr. Daybell on the stand.
I'm going to sustain the objection on the ground that it's been asked and answered. I think it was asked the exact same way. I don't think he answered it in the way that you wanted him to answer it, but it has been asked and answered. Let's move on.
Okay. Now, officer, your testimony originally was that the last time that they saw JJ was the 22nd of September.
Objection, that's vague reference to they. Doesn't state who that is.
So the objection is to foundation?
Yes.
All right. Mr. Pryor, do you want to lay a little bit more foundation before engaging in a conversation on that date?
As part of your investigation, you were able to ascertain a date based on reviewing pictures and evidence of when you believe the last time JJ Vallow was seen. Is that correct?
That is correct.
And as part of your testimony to today, you said you believe that the last day was the 22nd of September. Is that correct?
That is correct.
Okay. Now, as part of your investigation, did you contact JJ's school?
Yes, we did.
And as part of your investigation, were you able to ascertain the last day that the school had him registered and attending school?
Yes,
And that was the September 23rd, was it not?
that is not correct.
Would it surprise you to learn that there are statements about J.J. Vallow attending school on the 23rd?
Initially, we talked to the school and we had an unexcused absence on the 23rd, but an excused absence on the 24th. So in the initial part of the investigation, we believe that JJ may have gone to school on the 23rd, but later learned that was not the case.
And as part of your investigation into that issue, did you record that conversation with any of the officials?
I did not personally speak to the school.
Do you know who spoke to the school?
Detective Dave Hope.
Now, you talked and made reference to hundreds of pictures and videos. Do you remember saying that?
That is correct.
Did you provide those hundreds of pictures and videos to the prosecuting attorney?
I assume that he had gotten the photographs that we have gotten.
Okay, but that wasn't the question. The question is you made mention of reviewing hundreds of photos and hundreds of videos. Okay.
Objection, I think he's misstating the witness's earlier testimony.
Mr. Pryor, will you repeat the question? And Mr. Wood, if you believe he is misstating the witness's testimony, I'll allow you to make the objection again.
Judge, the witness had previously said that as part of his investigation, he looked at hundreds of videos and pictures. I'm inquiring as to whether or not all of those videos, those hundreds of videos and hundreds of pictures have been provided to Mr. Wood as part of this case.
I'll allow the question. I'll direct the witness to answer.
During the course of the investigation, there have been numerous people that had played YouTube videos, friends that had uploaded things to the internet, things of that nature, which we saw Tylee or JJ on. The videos and photographs that we had obtained, the prosecutor has copies of.
Okay. But then other videos that you've used as part of your investigation that were on YouTube. And when you're talking about these videos, you're talking about people in the community who have posted videos and audio, who have, this has drawn a significant amount of local attention. Would you agree with me?
I would agree.
And there's been a significant amount of people posting videos, posting pictures, posting audio in Fremont and Madison County. Would you agree with that, sir?
Yes.
Now, as part of your search warrant, initially to go into the, and there were 3 apartments, if my recollection is correct, and please correct me if I make a mistake. There were 3 apartments that you sought and obtained a search warrant for, is that correct?
That's correct.
And the date that you sought that search warrant was when, sir?
November 27th, 2019.
And the purpose of that search warrant was to search to determine whether or not Joshua J. Vallow was present in any of those apartments. Is that correct?
That's correct.
Was the purpose of that search warrant to obtain information and gather evidence in other regards?
No.
The sole purpose was to go in there to look and see if there was a human person in any of those units. Is that correct?
We were looking for any person in those units and to see if we can find out the whereabouts of JJ.
Okay. Was it part of that? Did that search warrant scope include the ability to obtain and take evidence and information to help support you in a later time?
Yes, it did.
Okay. Now, when you searched Alex's apartment, and that was 107, is that right?
Alex was staying in 175. That's where his belongings were.
In 175?
Yes.
And who was the person who owned 175 or rented 175, excuse me?
On the rental agreement, I believe it was Alex Cox that was on 175.
Okay, and what number was Lori Vallow's?
107.
And you also went into 174, is that correct?
That's correct.
Okay. And Melanie Boudreaux's was what?
174.
If I could have just a moment, Judge.
You may. Mr. Pryor, Mr. Pryor, if you do not want that to be on the record, you need to push that button right in front of the microphone there, so that green light is not on while you're talking. If you hold it, you need to hold it down. Thank you.
So in 175, was there any indication that Alex Cox had any belongings in there whatsoever of any kind?
In 175?
Yes.
Yes.
Were there any indications that Alex Cox had belongings in 107?
107 was vacant.
Was there any indication that Lori Vallow had ever resided in 175?
Yes.
Okay. Do you have a length of time as to how long she was in 175?
No.
Are you of the opinion that Lori Vallow and Alex Cox were living together in Unit 175 at some time?
Objection calls for speculation.
Do you have any personal information as part of your investigation that Lori Vallow and Alex Cox were residing together in Unit 175?
I have no information that they lived there at the same time.
Okay. They may have lived there at different times in that unit. Is that what you're suggesting?
I'm suggesting when we did the surveillance, that's where Lori Vallow was residing, and we had
She was
located
residing where?
in 175.
Okay. All right. And we're going to get to the surveillance. We talked about that in a minute, if you may. So at any point, as part of your surveillance, did you see her residing in 107?
No.
As part of your surveillance, was there a recording of any of the surveillance tapes?
No.
Did you record anything?
No.
How many hours would you suggest you did in surveillance of the Vallow apartment 175?
Oh, 15, 20 hours worth, maybe.
Okay. You talked about phone records initially in regards to the November 27th inquiry. Whose phone records specifically were you looking at as part of your initial investigation?
Lori Vallow's and Chad Daybell's.
Did you inquire as to Alex Cox's phone records?
I believe we did. I'm not sure if it was on the 27th or not.
Okay. All right. Did you inquire as to when Lori Vallow and Alex Cox both moved here together? Approximately what date?
Yes.
When was that?
1st of September.
And you made some reference to the relationship between Lori and Alex. Do you have specific information that would suggest they had a very close relationship?
Yes.
And what information is that, officer?
Information we had obtained through Gilbert, Arizona, through their investigation.
And when Lori Vallow chose to move here on the 1st of September, Alex Cox at the same time moved here as well, did he not?
He did.
Okay. And in fact, they lived together for a portion of the time, did they not?
I'm not aware of that.
Okay. Is it possible that they did live together?
Objection, Your Honor. I fail to see how this is relevant.
There's
I'll
been an
move on.
objection as to relevance.
But I think I'm just going to move on. I think
Okay.
I can inquire in another manner about this evidence through another witness. Thank you.
Thank you.
I'd like to turn our attention now to the picture or the demonstrative evidence, and I believe it's exhibit number 10. And if you would be so kind again to get the pointer out and point where Mr. Daybell's vehicle was parked.
So the court record is clear. Exhibit number 10 has remained up on an easel for the entire time on cross-examination. And the inquiry is about exhibit 10 that still exists on the easel.
Now, how was the car parked in the driveway, officer?
It was backed into the driveway facing west.
Okay. So the car was backed in. Was it all the way to the garage or was it partially in the driveway?
Sir, if you look at this, was taken that morning.
Okay.
So that's exactly where he was parked that morning when he was sitting in the vehicle.
Well, I appreciate you pointing that out to me. What I would like you to do is verbalize how far close to the garage was the car in relation to the garage.
10 feet.
So 10 feet from the door of the garage towards the street, is that correct?
Rough guess, yes.
And Judge, may I have permission to move freely towards that exhibit?
There's another pointer, I think, that's over there. Is there not, bailiff? Is there just a... All right. If you're going to move over there, Mr. Pryor, number one, I'm going to require you to wear a mask. And then number two, do you plan on touching the exhibit?
No, Judge, in light of the court's concerns, I think what I'll do is I'll try to talk this witness through this as well, rather than, and I see where the court is going, and I agree. If I'm unable to do that, then I may request that the bailiff give me another pointer and we do it that way. I agree with the court.
Okay.
So in regards to the car being parked, and I will represent to you, officer, that I've been out to that house probably 6 or 7 times. How many times have you been out to the house?
15 or 20.
Okay, when is the last time you were out there?
The last search warrant I served on the residence.
Okay. Now, on that day, can you give me the date and the time, the month and the date of when you were doing the search again? It was in June, correct?
Which search are you referring to?
The search that excavated and removed the evidence from behind the tree and the pet cemetery.
That's correct, June 9th.
Okay. And on June 9th, I'm looking at that picture and you say that's a picture taken of that situation. Is that correct?
Yes,
And I'm looking at the tree and the tree looks like it has foliage on it, correct?
correct.
Now, when I'm in the driveway and I'm standing, and quite honestly, I'll represent you that I did the same thing you did. And the view to the tree back there where they found one of the remains is not particularly visible. So your testimony is that it is.
Objection that he's just testifying now.
The court is going to completely disregard any testimony or any information that's being provided by the attorney, Mr. Wood. If you're laying a little bit of foundation here for a question, Mr. Pryor, you may do so, but,
Okay.
but let the record reflect. Your testimony is obviously not
All right.
evidence.
So is it still your testimony that there's a visible line of sight between where the automobile was parked and that tree back in the corner where there were remains excavated?
I never gave the testimony there was a clear line of sight. I simply said that he was looking towards the pond area.
Oh, okay. So he wasn't necessarily, he looked over there. Did he look anywhere else at that point?
I saw him looking towards the pond area.
Okay. But the question was, did he look anywhere else?
I'm sure he did look.
Okay,
Other
so he was
places.
looking around. Is that correct?
No, sir, that's not correct.
He made motions to look in different directions. Is that correct?
He wasn't looking as intently anywhere else as he was towards the pond area.
And you can agree with me that it's somewhat alarming if someone shows up at your property and decides to bring a number of people to start digging up your property. Would that cause anyone concern?
Yes,
Okay. Now, I'd like to go to the, back to the tree behind what's called the pond area. When we're talking about the excavation of the pond area, how deep down was it that the remains were found in the pond area back there?
I'd guess 6-8 inches
Shallow.
shallow.
And then in regards to the pet cemetery, how far down into the ground in the pet cemetery?
I couldn't testify to that. I wasn't there when they
Okay.
began the initial digging.
Fair enough. And based on the 25, I'm sorry, I misstated that, didn't I? 15 trips that you took out there? Is that what you said?
Yes, sir.
15 to 20? On the
Yes.
15 to 20 trips out there, do you have a recollection of how big that pet cemetery is?
Not every trip that I made out there was to the backyard.
Okay. Do you have a recollection or an estimate, having been out, you've been next to the pet cemetery, correct?
That's correct.
And you viewed it, is that correct?
That's correct.
And you're trained as a police officer to recall facts and obtain evidence, is that correct?
That's correct.
So when you're looking at a site where they're exhuming evidence, it would seem fair to assume that you would have an idea about how large of an area this pet cemetery was. So can you tell me how large the pet cemetery is?
I didn't worry about measuring that. That's what the FBI recovery team was for.
Now, you saw a marker on the pet cemetery that marked the pet cemetery of a dog, is that correct?
A dog was dug up there, yes.
But you saw a post and like a monument or a picture of a dog.
That's correct.
Right? And that was basically almost like a headstone, is that correct?
I couldn't tell you what the statue was
Okay.
for.
But still, you don't know what the statue was?
No, what it was for.
Oh, what it was for. What was it a statue of?
I believe it was a dog.
Okay. So there's no doubt that this was a pet cemetery, is that correct?
That's correct.
And there's no doubt that this was a well-defined fire pit that was back there, correct?
Correct.
This wasn't a fire pit that was created out of the blue. It was a fire pit that was well established for a significant amount of time. Would you agree with that?
Objection calls for speculation.
There's a question. If there's speculation in the answer, I'll direct the witness to not answer. But if the witness knows the answer to that question,
Judge, may I redefine my inquiry a little bit to
You
help
may.
in that regard?
you may.
Thank you, Your Honor. When you're referring to a fire pit back there, was there an actual circular area where there was a fire pit?
That's correct.
Was there also an area where there was numerous places where they were burning various items? Is that correct?
I did not see that.
Okay. Now, you talked a little bit about your experience in identifying human remains, and that it offers a unique smell when you see human remains. Do you recall testifying about that?
I didn't testify to my experience on identifying human remains. I testified to the smell of a decomposing body.
Okay, and that is a very unique smell, is it not?
It is.
Have you ever had an occasion to smell what the smell of burning flesh smells like?
No.
Objection relevance. The witness never testified to that.
Well, he talked about the fact that when he observed the area of the pet cemetery, that he observed burned flesh and burned bones. And I think I ought to be able to inquire as to where his knowledge of making that representation comes from.
Just so I'm clear, I believe that the testimony pertaining to a smell came from the first uncovering of a body, and that's not the same place as the pet cemetery. So, Mr. Pryor, with that information, tell me where you're going.
Judge, I just want to, inquire, Judge, as to where he gains his knowledge of being able to identify that the remains were actually burned, and that the bones were burned. And I'd like to know where the source of that knowledge is.
So if you want to ask questions about his background on burned flesh or whatever else, you can do so. I'll let you do that. Mr. Wood, any other comments?
Do you have any experience in identifying burned flesh and burned bones?
Define experience. You mean
been part of investigations that have involved other burned bones or other burned flesh?
No,
Have you ever had an occasion to smell what it's like when human remains are burned or scorched?
yes,
Okay, and that lays off a very distinct smell, does it not?
it does.
And it's beyond pungent. It's a very, very easily identifiable smell when human remains are burned, is it not?
It is.
And that's something that would be very noticeable if in fact human remains were burned. It's very identifiable. You would agree with that, would you not?
Objection calls for speculation.
Judge, he testified about his experience. I think I ought to be able to inquire as to whether it's easily identifiable.
I'll allow the question. If the witness knows the answer to the question, he can answer. If he does not, he can say he doesn't know.
All right. Do you know whether it's easily identifiable in your experience?
Freshly burned flesh?
Any
This-
burned flesh.
This had been sitting out there for quite a while, so
Okay.
the overwhelming smell of the decomposition is what I smelled.
And I appreciate that, but what I'm asking you about is whether or not the smell of burning flesh is a very identifiable smell.
That's right.
And it's very, and it's not something that's easily disguised. You would agree with that, correct?
I would agree.
Okay, now let's go back to the chart. And let's go back to, excuse me, I said chart, Judge. I want to say exhibit number 10, the demonstrative evidence.
Noted.
Thank you, Your Honor. And I'll slow down, Judge. I think I think I'm getting a nod from our friend at the clerk saying for me to slow down. So, Madam Clerk, I will pace a little better. Thank you for your patience. When I'm looking at that aerial view, and I'd like you to take the pointer and put it at the front where Mr. Daybell's car is parked. Okay. Directly across the street, are there any residences?
There is a resident.
Do you know the owners of those residences?
No, I do not.
Okay, did you interview them?
I did not personally.
Did anybody interview them?
I can't answer to that.
Okay. Now, directly across where the pond is, we'll go to the pond and then we'll head towards the road. Is there a residence there?
There is.
And there's no obstruction of the view of that residence to the pond. Would you agree with that?
I can't testify to that, sir.
Do you see any trees that are blocking the view from that house across the street to the pond?
I can't see what's on the other side of the road
Okay,
based on
fair
this.
enough, fair enough. And now I'd like you to put the pointer on the pet cemetery. And from the pet cemetery, go to 1900. No, I'm sorry, go to the other street, not 1900, that street. And I'm trying to recall, and I'm sorry, my memory is the same thing. I'm trying to remember the name of the street. The name of the street is what?
200 north.
200 North, that's right. And across from the pet cemetery, directly across from the pet cemetery on the other side of the street is another residence, is there not?
There is.
And then if you take the house and you go on the corner of the house that's sticking out and almost kitty corner 200 and 1900, could you put the marker on that as well?
200 and 1900.
Yeah, just on the right there. Now, if you go on the opposite side of the street, there's a residence there as well, is there not?
Over here?
Yes.
Yes.
And then a kitty corner from the Daybell house, there's a white residence across the street as well, is there not?
Your Honor, I'm going to object. This exceeds the scope of the direct examination. We never spoke about neighbors or houses outside of the Daybell property.
This is the last question I'll allow, Mr. Pryor.
All right. Is there a residence kitty corner from the Daybell residence?
Where Chad's daughter lives, is that where you're talking?
Well, thank you for that, but yes, where Emma lived at one point.
Yes, right down here there is.
Right. So if I count correctly, there's 1, 2, 3, 4, 5 residences surrounding the Daybell residence. Is that correct?
That's correct.
Okay. All right. Thank you. Specifically, who was present at the excavation at the pond? Do you have a recollection of who exactly was there?
No, I do not.
Do you have a recollection of who exactly was at the pet cemetery?
Not everybody. No, I do not.
Do you have a broad estimate of how many people were there?
50, 30, 50, somewhere in there.
35 to 50 people?
That's
And
accurate.
those were a combination of the Rexburg Police Department?
Rexburg Police, FBI, and Fremont County.
How many FBI agents do you recollect being there?
I can't recall. I can't answer that.
Did you have an occasion to interview David Warwick?
We did.
Was that a recorded conversation?
That was the same time Melanie Gibb was interviewed.
So the question was, again, was that a recorded
I
conversation?
believe it was by Lieutenant Ball.
And you interviewed Ian Pawlowski,
Yes,
and you interviewed Melanie Bordeaux, is that right?
that's correct.
And now she's going by Pawlowski, is that correct? They're married, I guess, right?
Yes,
And again, were those interviews recorded?
they were.
And Judge, if I could have just a moment to review my notes, may I?
You may.
Thank you, Your Honor.
If you're going to speak to your client, please push that button.
Judge, I think that's all I have at this point. Thank you, Your Honor.
Mr. Wood, it is approximately 5 minutes to noon. Would you like to do redirect right now, or do you want to take a break right now and do redirect after lunch?
Your Honor, if we do any redirect, we'll wait till after lunch.
We're going to take a recess right now, then we'll reconvene at 1 p.m. And at that point, we will start redirect with Mr. Wood and the witness, Detective Hermosillo. We'll be back here in an hour.
Thank you, Your Honor.
All right.
All right, Crime Talk aficionados. That is the noon recess for the Chad Daybell preliminary hearing. Now, we talked about during one of the previous breaks that the prosecution was very methodical, laying things out. And I was watching some of the comments roll by. A lot of people do not like Mr. Pryor, Chad Daybell's attorney. However, he's actually made some points for the defense in this particular case. No one's asked the big question, what's the elephant in the room question, which is, who killed the children? When were they killed? Cause and manner of death. This detective was probably, told we're not going to go there, and they'll let the medical examiner try and do that. But the points that were scored here, so to speak, were that the detective on direct examination Detective Hermosillo talked about on direct examination that when they were digging up the burnt bodies as it relates to Tylee, that the odor was rather obvious of basically burned or charred skin and remains. And the officer implied through his answers that this was near this burn pit. And on cross-examination, Mr. Pryor brought out that this pit has been there all along, and that this is a very distinct odor if you're going to smell flesh burning, and that, it's very obvious. And the questions that were asked of the detective were, well, how many houses are around there across the street from Daybell's house? And he said, there were some 5 residences around there. And he asked, did you ever go back and talk to any of these individuals? And the detective Hermosillo said, no, he didn't, and didn't know who had. Well, my guess is that the defense has probably sent an investigator out, talk to those witnesses, or Mr. Pryor has himself, and they are going to say they smelled nothing. Think about it. If you were burning flesh, it's going to be noticeable, visible to others. I'm sure they have talked to neighbors who said they heard nothing, saw nothing, and you have seen a glimpse as it relates to what the defense for Chad Daybell will be. Obviously, that Alex Cox is the one that must have harmed the children, and he has no idea how those bodies got up there. And when they start talking about, oh, I shot a raccoon out on the property, the defense is clearly going to suggest, well, I just simply shot a raccoon. And oh, by the way, in that pet cemetery, you found the raccoon that was that he shot out there. So, a lot of people don't like Mr. Means. A lot of people think, hey, this is completely irrelevant. What questions, and why is the defense attorney asking these questions? Well, he's scoring points. He's may not seem like the big picture. You don't expect a knockout punch today, ladies and gentlemen, but Detective Hermosillo has testified today, and he talked about how this originally started out as a missing child investigation, produced the children. And what he has said is that, he's had contact with Chad Daybell, but he exercised his right to remain silent. He wasn't cooperating with him. Okay. That'll never come in at trial. And as we said in our earlier commentary, that would result in a mistrial. But nothing so far has been said of the elements of the offense, which is a conspiracy that he was involved in to delay the location or hindering the location, finding, discovery of these human remains. No evidence thus far as it relates to that he knew that the children were there. Now you can say, well, it's on his property, but let's be reasonable, ladies and gentlemen. If somebody throws something over the fence and it lands in your backyard, do you know that it's there? Maybe it's hidden by the bushes. Maybe you haven't gone out and walked your backyard. That's what the defense attorney for Chad Daybell is actually trying to do. And he is scoring a couple of points. And I'm telling you, from a defense attorney perspective here, he is scoring some points. And whether you like it or not, he made some points. Maybe not necessarily that the case is going to go away today, but he's made some points with his client who's saying, trust me, I got this. You're in good hands. Because he's objecting. Some of it's being sustained. The stuff that he's being, the district attorney is objecting to, and some of it was sustained. He knew he was going to lose that. This attorney, clearly much better than Lori Vallow's attorney. He is an experienced criminal defense attorney. He knows what he is doing here. That's one criminal defense attorney talking about another one. This guy knows what he knows what he's doing. Let's just put it that way. And, like I said, just because the bodies are there, they got to prove that there was a conspiracy and he knew about it, that he made an agreement, that there was an agreement between all three people. So unless there's some evidence that we haven't seen or been talked about in the affidavit for arrest warrant relating, GPS putting people there near their phones during a particular time, which may completely corroborate the fact that he shot the raccoon. I'm telling you, he made some points, and the district attorney is going to be, probably sitting there saying, wow, and that's a good thing about a preliminary hearing is it helps both people, both prosecution and defense, get a perspective of what the case they have. And like I said, it's one thing to make an allegation. It's another to prove it beyond a reasonable doubt in this particular case. So, another reason why we have rules about separate counsel, because it's clear that, at least from what I am perceiving, from what I took place, questions asked regarding Mr. Pryor was the fact that Alex Cox and Lori Vallow moved to that apartment 175 at or about the same time. They may have even lived there or sometimes together again. But clearly, it looks like he is getting ready to throw Alex Cox and Lori Vallow and say, hey, basically, these two must be doing something weird. And guess what? He had no idea. He's been duped. He is the victim here in this particular case, and basically taking advantage of his good nature. Probably because let's face it, Lori Vallow probably met him, rocked his world to the point where he's getting married 2 weeks after his wife dies of unknown causes. So anyway, so the court took a break until 1 p.m. So we too are going to take a break. So we'll let you all take a break, and we'll be back at 1 p.m. to follow the preliminary hearing of Chad Daybell. We'll follow it as long as we can, and then we will go. We'll go back and we'll provide commentary on it as well. So thanks for watching Crime Talk, and we will see you in about 54 minutes at 1 p.m. Have a great day.